It's an institute which has really bothered for the medical community.
The Institute of Medicine and Law. Medicine and Law. For putting up a wonderful show. This will, I'm sure, in days to come, be eye-opener for the government as well.
Justice means which is just for both the parties.
I think IML have succeeded in their mission to a large extent.
The laws are made in the parliament, that's true, but the expertness lies in the periphery or in the country. So this is the real team what I feel. There you can guide us, send a document after this panel discussion to me, and I will definitely see that certain fruitful things will come out of this panel discussion, and we will see the result in Rajya Sabha as well as I will give it to Lok Sabha also.
Either the legislature or the regulatory body makes a law, a written law.
When we went through this technology, we thought we should do it. We should have it in Bombay. Corporation is willing it. My commissioner is very much for it. They are willing to give fund for it. But the question was that what is the legal status?
So far as legality is concerned, I always been telling my judges in the National Judicial Academy that unless it is specifically forbidden by law, always try for something new. And if that is so, possibly the present scenario is that after this IT, the Evidence Act is also permitting the document definition is already broadened and all that. So this will also be covered in that act.
इस बात को सुनिश्चित करने के लिए कि भारत में अभी ये जो वर्चुअल ऑटोप्सी की जो प्रक्रिया है, ये पूरे सार्क देशों में भारत में पहली बार शुरू हो रही है.
As you are aware that criminal negligence cases reported by National Crime Record Bureau in India since 2017, data available from the NCRB for 5 years, that is 2017, 18, 19, 20 and 21. Total 888 cases reported. So this is an eye-opener data which is available, although it is underreported, because these are those cases where FIR has been lodged against the doctors.
Doctors have been protected in cases of medical negligence by the Honorable Supreme Court since 2005. 17 years have passed since then, and now there are more questions that need answers. Is this protection still required? Are there any new reasons to relook at this protection? Do we want our doctors to be under unnecessary stress while performing their duties? The National Convention is an attempt to get answers to these questions.
It's an institute which has really bothered for the medical community.
The Institute of Medicine and Law. Medicine and Law. For putting up a wonderful show. This will, I'm sure, in days to come, be the eye-opener for the government as well.
Justice means which is just for both the parties.
I think IML have succeeded in their mission to a large extent.
The laws are made in the parliament, that's true, but the expertness lies in the periphery or in the country. So this is the real team what I feel. There you can guide us, send a document after this panel discussion to me, and I will definitely see that certain fruitful things will come out of this panel discussion, and we will see the result in Rajya Sabha as well as I will give it to Lok Sabha also.
Either the legislature or the regulatory body makes a law, a written law.
When we went through this technology, we thought we should do it. We should have it in Bombay. Corporation is willing it. My commissioner is very much for it. They are willing to give a fund for it. But the question was that what is the legal status?
So far as legality is concerned, I always been telling my judges in the National Judicial Academy that unless it is specifically forbidden by law, always try for something new. And if that is so, possibly the present scenario is that after this IT, the Evidence Act is also permitting the document definition is already broadened and all that. So this will also be covered in that act.
इस बात को सुनिश्चित करने के लिए कि भारत में अभी ये जो वर्चुअल ऑटोप्सी की जो प्रक्रिया है ये पूरे सार्क देशों में भारत में पहली बार शुरू हो रही है।
As you are aware that criminal negligence cases reported by National Crime Record Bureau in India since 2017, data available from the NCRB for 5 years, that is 2017, 18, 19, 20 and 21. Total 888 cases reported. So this is an eye-opener data which is available, although it is a under-reported, because these are those cases where FIR has been lodged against the doctors.
Doctors have been protected in cases of medical negligence by the Honorable Supreme Court since 2005. 17 years have passed since then, and now there are more questions that need answers. Is this protection still required? Are there any new reasons to relook at this protection? Do we want our doctors to be under unnecessary stress while performing their duties? The National Convention is an attempt to get answers to these questions.
It's an institute which has really bothered for the medical community.
The Institute of Medicine and Law. Medicine and Law. For putting up this wonderful show. This will, I'm sure, in days to come, be eye-opener for the government as well.
Justice means which is just for both the parties.
I think IML have succeeded in their mission to a large extent.
The laws are made in the parliament, that's true, but the expertness lies in the periphery or in the country. So this is the real team what I feel, where you can guide us, send a document after this panel discussion to me, and I will definitely see that certain fruitful things will come out of this panel discussion, and we will see the result in Rajya Sabha as well as I with you in Lok Sabha also.
Either the legislature or the regulatory body makes a law, a written law.
When we went through this technology, we thought we should do it. We should have it in Bombay. Corporation is willing it. My commissioner is very much for it. They are willing to give a fund for it. But the question was that what is the legal status?
So far as legality is concerned, I always been telling my judges in the National Judicial Academy that unless it is specifically forbidden by law, always try for something new. And if that is so, possibly the present scenario is that after this IT, the Evidence Act is also permitting the document definition is already broadened and all that. So this will also be covered in that act.
इस बात को सुनिश्चित करने के लिए कि भारत में अभी ये जो वर्चुअल ऑटोप्सी की जो प्रक्रिया है ये पूरे सार्क देशों में भारत में पहली बार शुरू हो रही है।
As you are aware that criminal negligence cases reported by National Crime Record Bureau in India since 2017, data available from the NCRB for 5 years, that is 2017, 18, 19, 20 and 21. Total 888 cases reported. So this is an eye-opener data which is available, although it is a under-reported, because these are those cases where FIR has been lodged against the doctors.
Doctors have been protected in cases of medical negligence by the Honorable Supreme Court since 2005. 17 years have passed since then, and now there are more questions that need answers. Is this protection still required? Are there any new reasons to relook at this protection? Do we want our doctors to be under unnecessary stress while performing their duties? The National Convention is an attempt to get answers to these questions.
It's an institute which has really bothered for the medical community.
The Institute of Medicine and Law. Medicine and Law. For putting on a wonderful show. This will, I'm sure, in days to come, be the eye-opener for the government as well.
Justice means which is just for both the parties.
I think IML have succeeded in their mission to a large extent.
The laws are made in the parliament, that's true, but the expertness lies in the periphery or in the country. So this is the real team what I feel. There you can guide us, send a document after this panel discussion to me, and I will definitely see that certain fruitful things will come out of this panel discussion, and you will see the result in Rajya Sabha as well as I will give it to Lok Sabha also.
Either the legislature or the regulatory body makes a law, a written law.
When we went through this technology, we thought we should do it. We should have it in Bombay. Corporation is willing it. My commissioner is very much for it. They are willing to give a fund for it. But the question was that what is the legal status?
So far as legality is concerned, I always been telling my judges in the National Judicial Academy that unless it is specifically forbidden by law, always try for something new. And if that is so, possibly the present scenario is that after this IT, the Evidence Act is also permitting the document definition is already broadened and all that. So this will also be covered in that act.
इस बात को सुनिश्चित करने के लिए कि भारत में अभी ये जो वर्चुअल ऑटोप्सी की जो प्रक्रिया है, ये पूरे सार्क देशों में भारत में पहली बार शुरू हो रही है.
As you are aware that criminal negligence cases reported by National Crime Record Bureau in India since 2017, data available from the NCRB for 5 years, that is 2017, 18, 19, 20 and 21. Total 888 cases reported. So this is an eye-opener data which is available, although it is underreported, because these are those cases where FIR has been lodged against the doctors.
Doctors have been protected in cases of medical negligence by the Honorable Supreme Court since 2005. 17 years have passed since then, and now there are more questions that need answers. Is this protection still required? Are there any new reasons to relook at this protection? Do we want our doctors to be under unnecessary stress while performing their duties? The National Convention is an attempt to get answers to these questions. Good morning, friends. At the outset, I would like to take this opportunity to extend a warm welcome to all the esteemed panelists for sparing their valuable time to make it to this year's convention. At the same time, I also welcome all the online viewers watching this program live on a beautiful Sunday morning. The National Convention on Medicine and Law has always been a place for serious discussions on contemporary legal issues pertaining to healthcare. This year, it is no different, except for the fact that the current issue has come into focus again since March 2022, when a young doctor booked for murder in an alleged case of medical negligence was constrained to commit suicide. If the doctors, our healthcare providers, are forced to provide health services under pressure or under stress, it is definitely bound to affect the overall health of our society. Is this not true? Can anyone disagree with this proposition? And probably that was the precise reason that the Honorable Supreme Court granted protection to doctors in cases of criminal medical negligence way back in 2005 in the landmark case of Jacob Matthew versus State of Punjab. The Honorable Court had further observed that the protection provided to doctors against routine arrest or filing of an FIR by the police was only a stopgap arrangement till the time our parliament made a law on this subject. So in this convention, we are going to discuss and deliberate whether the reasons for providing this protection are still good, or should this protection be done away with, or should something else be added, perhaps some additional procedural safeguards. What legal changes are required which could help everyone, the patients, the doctors, and the society as a whole? Should the parliament make a new law or not? We will attempt to find the solution, a solution that will be good for all, a solution that will be pragmatic, that can be easily implemented, a solution that will cause minimum harm. We are certainly not here on a fault-finding mission, but we are here to collaborate, to find the best answer in the given circumstances, an answer that will remain relevant for the future too. Friends, amongst us today, we have distinguished judges who have adorned the highest constitutional courts of this country, and judges who have graced the Law Commission of India. Their valuable opinions, suggestions, and their reasonings will help us in our endeavor today. We also have amongst our panelists today the lawmakers, including the chairman of the Parliamentary Standing Committee on Health. His learned views will help us in understanding the dilemmas of the Parliament on this subject. Moreover, he is amongst the best persons to convey our views before the lawmakers of this country. We also have here today eminent lawyers, doctors, administrators, regulators who will also help us in shaping our thoughts and ideas on this important topic. Last but not the least, we are here at the most opportune time. This is because the Honorable Home Minister of India, Shri Amit Shah ji, had recently stated that the criminal laws are under review by the government and certain amendments have been proposed
in the Criminal Procedure Code. On behalf of my organization, Institute of Medicine and Law, I assure you that we will soon come out with a white paper drawing insights from today's discussions and will share it with the policymakers and the opinion leaders. This convention is not the end, but the beginning of a new journey. With these few words, I would now like to introduce the chairperson of this event, Professor Dr. Ved Prakash Mishra. Dr. Mishra is a professor of excellence, professor of eminence, professor emeritus, and a distinguished professor. He has the DSc honoris causa by 7 different universities. He is the national head of the academic program and UNESCO chair in bioethics HIFA and member of the International Committee for Bioethics for Asia Pacific region. He also happens to be the chief advisor to the Honorable Chancellor and Krishna Institute of Medical Sciences, Karad, and the Pro-Chancellor, Datta Mege Institute of Medical Sciences, Nagpur. I now invite him to inaugurate this convention and start with his opening remarks. Thank you. Over to you, Dr. Ved Prakash Mishra.
Thank you very much, Ravendra. I deem it my pleasure to be participating in this very laudable initiative of relevance, wherein the participation which has been invoked, in my understanding, can be categorized into 3 distinct preambles. It's a congregation of eminence, it's a congregation of prominence, it's a congregance of relevance, and therefore we have every reason to believe that we shall be in a position to come down to a consequence which will be of desirable nature. Very rightly put in, we are sitting at a situation where violence against doctors and therefore remedial measures thereto have turned out to be an inevitable necessity. We shall be deliberating on the various aspects of it. But as very rightly pointed out, contemplation of a law which would be of use, which would be of utility, which will be having appropriate teeth, deterrent in nature and character, and therefore it will be in a position to invoke a required impact, turns out to be the necessity. Right from the historical perspective, from Jacob Matthews to Permanent Katara to various state enactment laws against violence, is a matter of historicity which is already there on the annals. And in the context of the fact that ultimately there is an inevitable necessity whereby a single little example should be in a position to prove. For the first time, the Indian Epidemic Act came to be amended, and that was through issuance of an ordinance during the context of corona pandemic plaguing the country. The 4 important inclusions which were incorporated in the Indian Epidemic Act, absolutely timely, relevant, and they definitely have proved to be of impact. The material question is a healthcare worker not entitled to safe environment? Is he not entitled to security and safety is $1 million question. Is that not a part of the legitimacy? Is it not that a part of within the scope and meaning of the doctrine of legitimacy of expectations? And therefore, if that be the case, it is not that it is a unilateral security or safety that is being expected. It is a safe, secure environment which will entitle him or her to render the best which is mandated in the given situation and circumstances in the larger interest of the welfare and well-being of the patient and the generic population as a whole. Therefore, ladies and gentlemen, there are roles within roles, there are situations within situations, and there are ways and means in which there are aspects which need to be dealt in a timely manner. The fact that in general, the opinion is that there is a need for the amendment of the Criminal Procedure Code and incorporation of the provisions in the criminal laws, which Government of India has said through its Honorable Home Minister that the matter is open for review. I think this initiative definitely will pave the way, as rightly put in the introductory remarks by Dr. Ravindraji, that we would be in a position to invoke the required inputs which will be generated out of this gathering of eminence, consequence, and relevance, which definitely, in my humble opinion, will go a long way in impacting the required decision making at the policy level. And let us hope that we will be in a position to generate a new dawn for the generation of a new era, entitling healthcare workforce in the country to be entitled to legitimate security, safety, and safe environment to generate the best out of them in the larger interest of people and population of this country, thereby really going to actualize the welfare state enshrined in the Constitution. With these opening remarks, once again, thanking the organizers and also welcoming all the learned participants participating in this entire 2.5-hour discussion. With these opening remarks, I am putting across this for the open discussion amongst all concerned. Thank you very much.
Thank you, Dr. Mishra, for those kind words. I now move on to the convener of the event and invite Advocate Mr. Mayank Shirsagar to initiate the proceedings. Before that, I will try to just briefly introduce Advocate Mayank. Advocate Mayank Shirsagar is an advocate on record, Supreme Court. He is representing clients in a wide array of civil, criminal, and constitutional matters with a strong focus on cases on medical negligence. He also happens to be on the board, on the editorial board of the Medical Law Cases for Doctors, a journal published by the Institute of Medicine and Law. Over to you, Advocate Mayank.
Thank you for those kind words, Ravindraji. No intention to do wrong. No sensible professional would intentionally commit an act or an omission which would result in a loss or injury to the patient, as the professional reputation of the person is at stake. A medical practitioner does not gain anything by acting with the negligence or by omitting to do an act. Unfavorable results are confused with negligence. That is what the present scenario in which we are here to discuss how and what extent the protection is required for doctors. Simply because a patient has not favorably responded to a treatment given by a physician or a surgery has failed, the doctor cannot be held liable per se. Dear participants, viewers, and esteemed panelists, I welcome you all to this convention. We have a very distinguished panel of speakers who will be sharing their views on this burning topic, and I'm sure that we all will get deeper insights and come out with some useful suggestions for the greater good. Ravindra Mangalji has already set the context. As the convener of this national convention and a practicing lawyer, let me throw some light on the Jacob Matthews judgment, which is a focal point of today's deliberation. The judgment clearly lays down that the purpose law is trying to achieve by punishing a doctor for negligence is, and I quote from the judgment, to make the life safer and to eliminate the possibility of recurrence of negligence in future. On the other hand, Honorable Justice Dahoti observes in the judgment that the consequences that flow from a doctor's fear of legal proceedings could be disastrous. If I may quote from the judgment, a surgeon with shaky hands under fear of legal action cannot perform a successful operation, and a quivering physician cannot administer the end dose of medicine to his patient. He further observes, discretion being better part of valor, a medical professional would feel better advised to leave a terminal patient to his own fate in case of an emergency, where the chance of success may be 10% or so. rather than taking the risk of making a last-ditch effort towards saving the subject and facing a criminal prosecution if his efforts fail. Such timidity forced upon a doctor would be a disservice to the society. There are other adverse consequences that flow from the indiscriminate prosecution of doctors. It distorts the doctor-patient relationship, and such patient will not benefit of the such punishment to the doctors will not be in the benefit of the patient in the longer run. In fact, Honorable Justice Lahoti goes to the extent of stating that it is also unjustified to impose on those engaged in medical treatment an undue degree of additional stress and anxiety in the conduct of their profession, and that this is counterproductive and does no service or good to the society. There are a number of reasons cited in this judgment giving special protection to doctors. Some may be more relevant, other may be less relevant today, but all relevant, 100% relevant even today. Simply prophetic, let me quote a few of these reasons as laid down by the Honorable Supreme Court. Human body and medical science both are too complex to be easily understood. Dealing with the case of medical negligence needs a deeper understanding of practical side of medicine. For a medical accident or failure, the responsibility may lie with the medical practitioner, and equally it may not. The inadequacies of the system, the specific circumstances of the case, nature of human psychology itself, and sheer chance may have combined to produce a result in which doctor's contribution is either relatively or completely blameless. The factors of pressing need and limited resources cannot be ruled out from consideration. One may have notions of best or ideal practice which are different from the reality of how medical practice is carried on or how in real life the doctor functions. Cases of doctors, surgeons, and physicians being subjected to criminal prosecution are on an increase. The investigating officer and the private complainant cannot be always supposed to have knowledge of medical negligence so as to determine whether the act of the accused medical professional amounts to rash or negligent act within the domain of criminal law. The criminal process, once initiated, subjects the medical professional to serious embarrassment and sometimes to undue harassment. He has to seek bail to escape arrest, which may or may not be granted. At the end, he may be exonerated by acquittal or discharge, but the loss which he has suffered in his reputation cannot be compensated by any standards. Many incidents involve a contribution from more than one person, and the tendency is to blame the last identifiable element in the chain of causation, the person holding the smoking gun, the doctor. With these judicious and wise words pronounced 17 years back by the then Chief Justice of India, Justice R.C. Lahoti, I invite the speakers of the convention to share their views, and I hereby request the moderator, Dr. Parag Ridhani, to take over the session and sail us through the journey that we have begun today morning. Let me give a short introduction of Dr. Ridhani. Dr. Parag Ridhani is a CEO of Wockhardt Hospital, Maharashtra, and is an esteemed panelist today. And apart from that, a student of medical law and negligence. Over to you, Dr. Ridhani.
Thank you very much, Advocate Shrisagar. I really appreciate the opportunity. I'm just going to express a few points of view which will be in divergence to the law and negligence that we're going to be discussing today. I think there's a huge emotional component behind every child becoming a doctor. Every middle-class family aspires that their child either becomes a doctor or a lawyer or a chartered accountant. And when a child finally gets into medicine, after with all the reservation and all the difficulties that we face post-12 standard, there is an aspiration that the child will become a doctor, will serve society. And when the child finally goes out into society and starts serving society, suddenly one day the parents, the family of the doctor get to know that the child was beaten up or the child committed suicide, whose Like there is a level of maturity which is absent in society today, which is unable to fathom that there are things beyond doctors taking responsibility for everything. And I think there is a Supreme Court judgment which starts off only with saying that doctors are not gods. And I think that's something that we should be aiming to look at today. The other important thing which I'd like to also look at is in the years to come, other things that we need to discuss at this forum would be also how to decriminalize, how to clean up the role of doctors and healthcare in general from this portrait of profit-making, very devious professionals actually commit themselves to saving lives. It's not just the Bollywood or the society at large or media. There are even doctors who speak about this in a large way. I'm not saying that we don't have those bad apples, but not all apples are bad. And I think that we all finally need to look at it from the individual family point of view. When a doctor loses his or her life, there is a family that's left behind. There are patients who suffer. And in a country where we're already suffering from an extremely, extremely low percentage of doctor to population ratio, more pronounced in certain areas than the metros and the larger cities, it is very, very important that we seek to resolve these issues so that doctors are not made to suffer. I have personally been at the receiving end of physical and mental harassment in my role as a medical administrator in a hospital. And I have personally gone through the stress that one goes through. I've had security outside my room for over 20 days under pressure from political elements who sought to criminalize this entire death that happened at a particular time. So I think it's high time that we understand the need for this representation. And I'm extremely, extremely glad that society is now finally waking up to this. With those opening remarks from my side, I'd like to yield floor to my first panelist. My first panelist is somebody who has spoken out earlier and needs to speak out again, especially at this forum. Ladies and gentlemen, I request Dr. Suneet Upadhyay to please speak now. Dr. Suneet Upadhyay is an addiction psychiatrist, a sexologist, and a neuropsychiatrist. He's also the husband of late Dr. Archana Sharma. Dr. Tripathi, I'd like all the panelists to kindly yield time so that Dr. Upadhyay is able to speak out and is able to be heard on this forum as well. Over to you, Dr. Upadhyay.
Thank you, Dr. Bharat. Am I audible?
Yes, Dr. Upadhyay, you're audible, sir.
Actually, I would like to say that governments are so lazy in implementing actions against their officials. Like in my case, SP has accepted that he gave the order to lodge an FIR because it was government's policy to accept every FIR. He sorted this in his written statement. Despite of that, government has not taken any action against that SP or SHO and DSP. They have deliberately done it just to protect their officers. They are working. Government is working for that only. Second thing, using dead body as a bait is a most problematic thing. The doctors comes under stress. When there is a dead body outside the hospital, doctor cannot sleep, doctor cannot eat. He is always a threat that people might come to harm me, harm my family. I have seen face of my wife and she was continuously crying when dead body was outside the hospital. So she could not recover of that agony. So hazardous situation is for doctors and it is an irreparable loss of society. All people of village come to me that said she was a great doctor, she saved so many lives. We are at loss because of some goons and it's government's inactivity. That was my perspective. The central role is the must. When some officers will be punished for the action against the doctors or lodging FIR against the doctor that they did it wrong, officer will be punished, then only message will flow in the country. The doctor officers can also be punished for this wrongdoing. That's why central law is a very essential thing.
Dr. Upadhyay, I'd just like to interject and ask you one more question. Once the law is actually made law, by honorable parliament members, how important do you think it is to be able to percolate this knowledge down to the smallest sub-inspector, the smallest village, taluka, district level? Because at the end of the day, what we've seen, we're dealing today with organ transplants, and we see that even in a city like Mumbai, these laws are not very well known, and still, patients are harassed with all of this. How important do you think this percolation is going to be, sir?
Yes, informing the officials about it is not enough. We have already informed that SP that in the Jacob Matthew case, you cannot lodge an FIR against us. But even then he ordered for it. It is not a situation that he was not aware of this Jacob Matthews case. We, team of doctors, informed him, but he did not accept it because there is no example that if you make a wrongdoing, you lodge FIR against the doctor, you will be spared by the government. They are in this impression. So strict actions against those erring officials is essential. Once a police officer is punished for this wrongdoing, he will have to, a message will be spread all over. Just sharing the information is not enough, I think.
Okay. I think that's extremely moving to hear it from the husband of a doctor who's actually lost her life due to the stresses that we face day in and day out. We have Honorable Justice Ashok Kumar Ganguly, who needs to exit this conference due to some prior commitments. Honorable Justice Ganguly served as the chairman of the West Bengal Human Rights Commission and also as a judge of the Supreme Court of India, who delivered judgments in some extremely high-profile cases like the 2G Spectrum case. Honorable Justice Ganguly, your views on this matter, please.
Sir, you are on mute.
Now, am I audible?
Yes, Honorable Justice.
Thank you. Good morning to all of you and the distinguished panelists. This problem is a complex one because we fail to realize that in some cases death is inevitable despite the best service by the doctors. Therefore, whenever there is a death occurring in a family, in most of the cases, emotions run high and we tend to blame the doctors. Not in all cases there is violence, but the blame is almost laid at the doorstep of the doctor. This is very unfortunate because in criminal law, negligence is different from negligence in civil law. This has been explained very well in Jacob Matthews' case. In civil law, negligence means a civil wrong, a mere lack of care. But in a case of criminal negligence, the learned judges in Matthews' case made it clear, unless there is a case of extreme act of rash negligence, it does not come within the concept of criminal negligence. And the learned judge in the judgment has referred to several exceptions which are already there in Section 88, Section 92, Section 93, where it is made clear that causing death of a person with the consent of the person or without the consent of the person, but with the intention of causing benefit to that person, giving him some relief. There are several illustrations given, does not amount to the case of murder. But 304A, which is the provision in the IPC for causing death by negligence, is of many cases applied against doctors. Though there are certain guidelines given in Jacob Matthews' case, the previous speaker says that despite knowledge of Jacob Matthews' case, the FIR is lodged against the doctor. Now, I tell you, it is very difficult for the officers to understand the implication in Jacob Matthews' case. Unless the observations which are made in Jacob Matthews' case, the precaution of the guidelines which are already there are transformed into the letters of law, it is difficult to guide our officers running in charge of criminal administration all over the country. It's very difficult. So it is high time for the Parliament to come forward and review this old colonial legislation of IPC and make it in tune with the present needs of the time. As has been said by Judge Holmes, one of the greatest judges, the life of law is not logic, but experience. So over the experience which I have gathered in the last few decades, it is high time, in my very humble view, that Parliament should step in and, in the light of directions given in Jacob Matthews, amend the IPC to make it, to give some real safeguard against the doctors. Otherwise, there will be this unfortunate things are happening all over India. And much to our discomfort, much to my dislike, but this is happening, and in many cases, these are accepted in society. It's a social malady. Violence against doctors is a social malady, not only a mere misunderstanding of the legal situation. We always blame the doctor for something which is beyond his control. Even by applying the best care and best expertise, sometimes the inevitable cannot be avoided. But as soon as this happens, we go and rush and blame the doctor. It's a very unfortunate situation. This needs immediate attention of the august body of our Parliament. These are my views.
Thank you very much, Honorable Justice Ganguly, sir. I just also wanted to bring one thing to the fore for our lawmakers. As healthcare providers, all of us essentially function on the premise of primum non nocere, that is primarily do no harm. Even engraved very beautifully in our Hippocratic Oath is the fact that we all endeavor to work with medicine in such a way that the patient remains at the focus of safe, relevant care. And I think what's extremely important, as we will now hear from the doctors, panelists, is the fact that today all healthcare, whether it's the medications that we dispense, whether it is the equipment that we use, whether it is the facilities in which we function, all of them are becoming safer and safer and safer. The burden of negligence is something which it does happen. We are not saying that doctors are perfect, but at the same time, there has to have to be proper ways of dealing with it. There has to be a channel to work with this. With these words, I'd like to invite Honorable Dr. Gurbir Singh. Dr. Gurbir Singh is the Professor Emeritus at Chitkara University. Sir, we've interacted last year also on this platform, and we know that this is a platform that yields to results. Over to you, Dr. Gurbir Singh. You have about 3 minutes to present your views on this topic, sir.
Thank you very much, Parag, and all the honorable members on the panel. Now, I am always reminded of something. Let your faith be bigger than fear. But alas, there exists no proviso as yet to help us garner such faith. Now, there is what has been explained by the various other preceding speakers, so I will not repeat what they've said. But then, very true is when a healthcare provider is battling a baffling patient scenario, and this gets coupled with uncontrolled, irrational fear of the unknown, it definitely destroys peace, calm, and tranquility of the mind. And that is not a very, very, ideal situation for a healthcare provider to be handling a human life. Now, and again, it was mentioned by the good doctor who has suffered a personal loss. We are all blamed of having chinks in our armor as far as our professional knowledge is concerned. And maybe, yes, there are advances which may not have, crossed my eye or my mind. But like the moderator said, that do no harm. And that is the motto with which we start ourselves from the home when we do that. Now, is the ignorance on the part of the police member or the variation in their application of knowledge to a vulnerable, timid, and often soft soul like a healthcare provider a tenable defense? I don't think so, because whenever we make a mistake on the road, ignorance is not the best defense is what we are slapped in the face with. And now what I'm trying to say is that when I go for work as a doctor, I do wield a pen which is mightier than the sword. Fair enough. But my eyes only see the good for the individual whom I am treating. Now, when I sit in the chair and I was the regional medical director with the Fortis, when you have an eminent professor come hanging his head down and saying, I know I can help this individual, give him a quality of life. God will decide the quantity of life. Now, that is the vexing part when he has to take a decision whether not to treat the individual. And by doing so, either ways, I feel he has failed in his duty as a healthcare provider. Now, Parag, these are all some things which they said. And now, if you see, if we were to believe there is nothing beyond the corner, and if the lawmakers feel that reality is the thing which is lying beyond the corner, then is it safer to assume danger and expect the worst, or to be assured of a peaceful state of mind while dealing with a human being and a fellow being? Thank you very much.
Extremely well put and extremely crisp, Dr. Singh. I think the point that you've rightly made is that should we actually ever try to treat? Because if we start assuming that every patient is going to sue us and every relative is going to beat us up, I don't think we'll be in a position to render care. So we do continue with the Good Samaritan in us, the educated professional in us who wants to serve society. And I don't think there is any escaping that, sir. I'd like to move on and request Dr. A.V. Jayakrishnan. Dr. Jayakrishnan is a consultant neuro and spine surgeon at the EMS Memorial Hospital in Perinthalmannan. He is also the secretary of the NPPS at IMA headquarters. Dr. Jayakrishnan, how does IMA and your personal views also see this problem? What do you think we should be recommending to the lawmakers, sir? Over to you, sir. You have 3 minutes, sir.
In the meantime, may I leave with a petition?
Yes, sir.
Honorable legal luminaries and respected faculties, dear friends. It's a very pertinent topic that we are discussing today. Actually, the criminal liability in medical practice is a worrying problem for all the section of medical practitioners, and not only medical practitioners, the health workers itself, because even nurses are being dragged to court for criminal negligence. And doctors face a lot of stress due to the potential threat of being dragged to court, arrested, etc. And the incidences are increasing for the past 2 decades. And in each and every case, due to, as discussed by the panelists, due to the political interferences or due to communal issues, etc., unnecessarily criminal cases are being thrust upon. And the only savior for doctors regarding at present is the Supreme Court verdict in the Jacob Matthew case, in which they have suggested some guidelines, like for preventing arrest of doctors. The guidelines say that there should be an expert committee by either a district expert committee and a state expert committee, etc. But in practice, what we often find is the expert committee is usually incapable of distinguishing between a gross negligence and a routine negligence, and an institutional negligence and an individual negligence. This is what we usually find. And due to this, unnecessarily cases are being thrust upon the doctors. That is one of the things. Even is sent to such a district committee, which comprises of the district medical officer, some forensic expert, a legal person, etc. Usually, whether it's a gross negligence or some form of negligence, what is the institutional component, all the things are not being distinguished. Another area is, other than IPC, many other special laws like the MTP Act, POCSO Act, PCPNDT Act, all these drag out doctors to under criminal cases and even they get arrested due to various reasons, even for not filling up a form. So these are some other instances other than IPC in which doctors have criminal liabilities. And another important thing is that the Supreme Court had even suggested the Medical Council to make some guidelines regarding how the expert committee should function and all. The Medical Council had given some guidelines in 2018, but I think it's not still finalized. And now the expert committee does not have a proper guideline how to distinguish between a criminal negligence, civil negligence, etc., how the negligence can be thrust upon. And another thing is that the latest NMC guidelines, NMC GMC guidelines, guideline 4, just states how in penalties the doctor should be assessed. And in it, it's told that always the attributability and severity of the cases should be analyzed, and there are some guidelines. That is not regarding criminal negligence, it's a general guideline, but still all these things should be applied by the expert committees when they come to the assessing a particular case. And another important thing is that we should have a special law, because there is no mens rea in any cases of similar negligence, and these should not be come under a criminal negligence in IPC. And even the medical councils are unarmed in cases of negligence. Ideally, even a greater thing to be taken to for against medical practitioners regarding negligence is action by the medical councils, because it's an issue with medical negligence, and the medical councils have the power, or the National Medical Commission and State Medical Commission have the power to temporarily or permanently do a penal erasure of the doctors. And even they are qualified to judge these cases, and the role of medical councils should be increased. So on behalf of IMA and on my personal behalf, I request that there should be some intervention, some law by the Parliament to exclude medical professionals from the criminal responsibility in medical practice.
I think Dr. Jayakrishnan has hit the nail on the head, and he's actually articulated it extremely clear. This is his personal stand as well as the stand of the Indian Medical Association. Being a proud member of the Indian Medical Association, I would also second that. And we'd like to move on to Dr. Krishnendu Mukherjee, sir. Dr. Krishnendu Mukherjee is a consultant general and vascular surgeon from Kolkata, and also an examiner at the Royal College of Surgeons of Edinburgh. Dr. Mukherjee, your views on this topic. Where do you stand on this, sir?
Good morning, everybody. Respected dignitaries and judges, I hope I'm audible. I want to make one very important point, that if the situation remains as it is and lawmakers or parliamentarians only make certain modifications to the existing act, nothing is going to change on the ground. We have studied a series of cases where aggrieved family of patients who have died have actively pursued a criminal case with the local police station. In about 8 cases out of 10, there are local questionable elements, nefarious elements of the society who are involved. Sometimes local political nepotism is involved, and there are factors which are not in the control of either of the doctors or of the wider society. So what we need to do is Section 304A IPC and Section 337 and 338 of the IPC. These will not be applicable to those jobs, not only doctors, those jobs where death of another person is one of the likely or spontaneous endpoints. We need to understand that morbidity and mortality are spontaneous endpoints of the medical profession. It is the same with soldiers. It is the same with security forces in a conflict zone. So what has to be done at a lawmaker's level is that a certain list of jobs, occupations, or professions will have to be protected from 304A, 337, and 338. However, that does not mean that criminal liability will be completely, these occupations will be completely safe from criminal liability. No, National Medical Council has now replaced, National Medical Commission has now replaced the Medical Council of India. Their draft regulations were in the public domain. The state medical councils and National Medical Commission, if they investigate a case, they themselves will be able to suggest in which particular case a criminal liability might be present and further investigations may be done. My humble submission is that certain jobs, certain occupations, certain professions, not only medical profession, they have to be shielded from 304A IPC, because causing death of another person is a very possible and likely outcome of the very nature of that profession or that occupation. As I gave examples like a soldier or a security force. Any other modification or cosmetic change will not work, because at the ground level, doctors are harassed because of political nepotism and because of nefarious elements in the society. Thank you very much.
Thank you very much, Dr. Mukherjee. And I think it's extremely, extremely relevant to understand what you said, that death is the potential outcome of any activity that we undertake. While we do take consents for death on table, for high-risk complex cases, for death due to anesthesia in really complex cases, it's extremely relevant for the lawmakers to understand that. And I think I will echo the sentiments of Honorable Prime Minister, who keeps talking about one nation, one uniform. I think though health is a state subject, we must ensure that the law, once it is made, is actually percolated throughout the width and length of the country, so that our doctors are actually safeguarded. Not just doctors, as Dr. Jayakrishnan said, but also our nurses and other technical staff. As we move forward, I'd like to quickly jump on to a video message from Dr. Arul Raj, who is the past president of IMA and API. He is unable to join us as he is attending the Commonwealth Medical Association conference at Kuala Lumpur, but he has graciously sent us a message. May I request the tech desk to kindly play the video message of Dr. Arul Raj? Mr. Agasti?
Second important thing is on the prosecution side. On the prosecution side, there are two issues. One is an FIR filing, another is an arrest of doctor. For FIR, Supreme Court of India has given clear guidelines. There should be a prima facie, and there should be an expert opinion, and there should be a superior officer, and then by Boehm's test it should be done, and that has to be applied. And secondly, when there is a arrest of the doctors, maximum it should be avoided unless there is a criminal issue, cannot be. And Supreme Court has given a direction to the Government of India as well as Government of States in consultation with the Medical Council to prepare the guidelines and put it across, but it has not been done. Now these guidelines have to be made, incorporated into the IPC. Thank you very much.
Thank you very much, Dr. Arul Raj, and thank you, TechDesk, for helping us with that. I think extremely, extremely clear opinion on where we need to be, as also the relevance of Boehm's law. I'd like to now invite Dr. Atul Shah, who is a practicing doctor and also the former president of the Association of Plastic Surgeons of India. Dr. Atul is an old friend. Atul, over to you. You have 3 minutes to present your views, please.
Thank you, Parag. Good morning to all. In the recent time, we have been seeing a lot of news items which may or may not relate to the problem at question for today's deliberations. But you would realize that number of post-graduation seats are going vacant in the medical field. You would have read about several instances of more and more assaults on doctors and healthcare staff happening. You would have learned that number of negligence cases, not only in consumer commissions, but also through police, are increasing. And on top of all, as it happened in Rajasthan, the insensitivity of administration and insensitivity of police has come to the surface. Recently, we changed from the Indian Medical Council Act to National Medical Commission Act, and now NMC is armed to have several rules. Recently, we got new rules framed which are being asked for public opinion is about the qualification of medical teachers. In very recent past, they came out with even rules concerning the hair transplant. So it's very, very important now that once and for all, either through IPC or through NMC, a stricter language of the rule must come on platform which concerns these three things which go hand in hand. One is about negligence, be it civil or criminal. Second is assault on doctors. And third, very important, I feel, is about capping on the amount of compensation, because problems occur as patients and relatives realize that they can walk into a consumer commission or into police station and ask for hefty commission, and also at the same time see to it that a treating doctor or a treating team is taken to task. So it's not just a solitary question of negligence and the arrest of doctor, but two other things come hand in hand. One is assault and second is the amount of compensations that are being awarded. Thank you, Parag.
Thank you, Dr. Atul. I just quickly want to move over to somebody who have been itching to ask a question myself. I'd like to ask Dr. Mukesh Yadav, who is the Principal and Dean of Rani Durgavati Medical College at Banda in Uttar Pradesh. Sir, your views on this topic, and my follow-up question, your views on incorporating an element of applicable laws and liabilities at the medical college second, third year kind of level, also healthcare quality actually. Your views on that once you've presented your views. Dr. Yadav, over to you, sir.
Thank you, Dr. Parag, for giving me opportunity, and I congratulate the whole team of IML for taking this initiative on a very important, pertinent issue, not only for the doctor community, but the whole mankind, especially in India. I would like to share few slides just to highlight the magnitude of the problem which I collected through the National Crime Record Bureau that will help in slides are visible.
Yes, sir.
So the theme which we put regarding criminal prosecution of doctor for medical negligence, statutory changes needed in IPC. I extend it to not only IPC, but the changes are needed in the CRPC as well as in the Indian Evidence Act and guidelines which are already playing after this Jacob Matthew judgment and Lalita Kumari judgment. Enforcement is very important, not only the law, changing law, and if not able to enforce in timely manner, there is no deterrence. The purpose of law is deterrence in the mind of either public or in the doctor community. So what I collected from this National Crime Record Bureau started publishing data on the criminal medical negligence deaths under section 304A since 2017, and I have data till 2021. So till these 5 years, total 888 cases have been reported. Average is 178 per year, maximum in 217, and this was pre-COVID in 2018. Minimum 129 in 2020 due to COVID time, where hospitals are closed, everything was standstill. And there are criminal medical negligence has been reported and number of regions. Further research is needed for that. Now come to this top 5 states which reported highest number of deaths due to criminal medical negligence. And as usual, UP is the highest, accounting for more than 14% of total cases, followed by Jharkhand 104, Rajasthan 94, Telangana 83, Haryana 68. Small state, number are very high. So these are the eye-opener figure. Even in metro cities, in 5 years, 77 cases have been reported.
These are those cases where FIR have been lodged, and this is the average and maximum and minimum cases. These are the 5 metro cities which reported highest number of cases, and Delhi reported highest 11 cases out of 13 in 5 years. Obviously, region is awareness among the public, and that state machinery and judiciary more sensitive in these places. Another important figure regarding age and gender of those who have been arrested. Out of these 662 cases arrested in 5 years, in spite of Jacob Matthew guidelines, I have no data whether that the procedure protocol followed or not. But as per the age group between 18 to 30 years, 129 cases, more than 19% cases are arrested. 31 to 45, 404 doctors, that means more than 61% arrested in 5 years. Between 46 to 60 years, 19.3% arrested. Above 61 years, doctors which above 60 years, less than 1% arrested. But there is no age which is immune from this criminal footfall. Then this 31 to 60 years, which is the most productive age for doctor to serve the society, more than 80% cases arrested as per the NCRB data. This is important. This shows that the follow-up of those SOP or guidelines of Jacob Matthew or Lalita Kumari are not followed. And again, fault is also with the medical community. When you go to the gender divide, more than 90% out of these 662 were male doctor, and less than 10% were the female doctors who have been arrested by the police. This is the figure of after that FIR. The disposal of these cases are at 2 levels, at the police level and another at the court level after trial. So this is the figure, and what is important, what is the charge sheet rate in these cases? In 2017, 64.8, then 62, average is about 54, more than 54% charge sheeting rate. That means rest cases either discharged or abated or whatever the reason. So what I want to highlight, what is the fun in making that FIR and harassing doctor if you are not able to come to that conviction stage? So at the disposal level, in 2017, out of 39 cases disposed, only 5 were convicted. Similarly, in 2018, 8, and percentage figure is also mentioned. So the maximum conviction is 20% in 2019. Minimum was 8.3% in 2020. When you take average, it is hardly less than 15%. So out of those 164 cases which are disposed by the court, only 15% convicted. That means rest 85% they have been acquitted. And then you can imagine, we can imagine the torture, mental torture suffered by the doctor, this police trial or even the court trial. So that is why these figures are important. I have taken also this zonal distribution of these medical negligence cases. This zonal distribution I took as per the Consumer Protection Act schedule 2019. They put certain state in particular zone. So Eastern zone region reported highest 234 cases in 5 years, followed by Western region, Northern region 219, then Southern region 177, Northeast state 38, so total 8 cases. So this is how this prevalence or incidence of criminal negligence is in the India. So now my point is whether there is need for change or not. On behalf of myself or my experience in tertiary care hospital as well as a president of Indian Academy of Forensic Medicine, we are taking this issue further. There is need for change, not only in the IPC, there is a need to maybe insertion of new section in the form of 304C, A, B, then C, which read down whatever is Jacob Matthew guidelines or Lalita Kumari guidelines. Then need for change in CRPC 154, which mentioned mandatory FIR incognizable cases reported to the police and arrest without warrant. Without that change, again, the deterrence on these police or executing persons cannot be held, or justice cannot be done to the doctor. Next is Indian Evidence Act. Expert, who is expert, not defined, nowhere it is defined, and that is why especially district level, rural area where no experts are available, this justice regarding whether it is a gross case or it is a simple negligence case cannot be decided. Here role of IML and IFM and IMA and other professional body is very important. We should come together and fight against this, because when you go to the, which in your opening remark, Dr. Parag, in contest to the Jacob Matthew guidelines, it is disservice to the society if you keep, say for example, out of these 888, that means 100 medical admission capacity के 8 medical college आप close करने जा रहे हैं. You are denying the public of those doctors services to those public to whom 99% we are saving life. 1 or 2 cases where natural consequence is the death, as in case of Dr. Archana Sharma, we are facing this tragic end of our esteemed colleague, and I can share empathy of Dr. Upadhyay. We have also constituted another society at India level, Medical Legal Society of India, mostly doctor with legal background, and we are trying to be intervening with the PIL filed in the Supreme Court by Dr. Sunil Upadhyay. So I request all the esteemed judges and the panelists and IML especially to please go forward on this issue, not only just limit to the presenting white paper, but to some logical end, and I am ready with IFM to support this wholeheartedly. Thank you.
Thank you. Thank you, Dr. Yadav. Dr. Yadav, can you just stop the share screen, please? Yeah, okay, fine. I think that was very, very informative, and thank you very much for taking this, taking the time to research it. I'm just going to give some time to our other doctors. And before we go ahead, I'd like to request Tech Desk to play Dr. Shrikant Shetty's video message. Dr. Shetty is a practicing doctor and the editor of the medical legal journal, Medical Law Cases for Doctors. I request you to kindly play his message.
What is the greatest fear of the medical profession today? It is the law. What should a doctor do? Should he continue to do what he has been trained for, or he keeps learning the new intricacies of law? As an editor of MLCD, I see so many frivolous cases being filed against doctors. If a doctor is negligent, he should be punished. But the frivolous cases are going to take time away from a doctor's professional life, where patient care is going to suffer. One of the speakers today has made a very good suggestion. Dr. T.N. Ravishankar has suggested medical tribunals for doctors. I think that should be looked into by the group today, hoping that the peers, the stakeholders who are involved in this discussion today can give new light for the policymakers to decide. Thank you.
Thank you very much. I'm now going to request Dr. Neeraj Nagpal. Dr. Nagpal is a practicing doctor, also the convener of the Medical Legal Action Group. Dr. Nagpal, your views in a crisp format, please. Over to you, Dr. Nagpal, sir. Is Dr. Nagpal present, Ravindra?
Parag, I don't think he has yet joined in.
Okay. I will move quickly to my close friend, Dr. Suganti Iyer. Dr. Suganti Iyer is the Deputy Director at the PD Hinduja National Hospital and Medical Research Center. Also works actively with healthcare quality with the National Accreditation Board for Hospitals and Healthcare Providers, a strong proponent of primum non nocere. Suganti, your views, please, madam. Dr. Suganti, your views, please. Yeah.
Yes. Very good morning and congratulations to IML for holding this program. The way I would look at it is that the doctors are bound with the judgmental laws, and which clearly says that saving the life of a human being is of paramount importance. This also is said in the Code of Medical Ethics, and the doctors also are bound by the Hippocratic Oath. Therefore, when they have undertaken to treat a patient because it is an emergency, and as a life-saving emergency, the patient has been admitted under them, or even if they have chosen to electively treat a patient and later on becomes a life-threatening emergency during the course of management, very often it is seen that the doctors are struck between the devil and the deep sea, because the course of the patient management, it is not like a computer where you give a medication and the response has to be there. The human being and the human body is a complex mechanism, and the response may be there, what may be thought of or not. And therefore, very often the doctors would like to give an extra dose of medicine or add another medicine or give for an indication which is not really standardized, going out of it, or they would like to do a surgery with an extra stroke of the scalpel. And this is primarily the intention is to save the life of the human being. Also, considering the fact that there has to be medical research, there has to be medical advances. Otherwise, how do we have today separation of Siamese twins? How do we have today the heart transplant? So many new medical inventions, medical research, and how will the progress of medical be there? Therefore, for the progress of medicine, the doctors have to take this extra struggle or the extra risk for giving medication or surgery. At that time, if they practice with a halter on the neck, as is told in the Jacob Matthews case, then it is much disservice not only in the course of management of the patient to save the patient life, and also a disservice to further inventions and further medical research, clinical trials, and progress of medicine. So therefore, any inaction or damage that is resulting should be treated as a mere inadvertence or a civil, or that is the way it should be, and not just because he's holding the smoking gun and he's in the field should be treated as a gross or a reckless negligence. The other thing which I would see, which I've been hearing constantly, yes, there would be change in the guidelines, and one would see the severity and also the standards by which one would say this is a gross negligence or this is a simple negligence or a civil negligence. Well said. The guidelines would be framed. Even Jacob Matthews' judgment has come out in 2005. As Dr. Parag Rindani earlier mentioned about the Transplant Act, that has come into 1994, and again TOTA Act with the Tissues Act has been in 2014, which clearly says that the police have to give an NOC for retrieval of human organs if it is a medical legal case. Let me tell you that practically the doctors, hospitals, etc., we are at the mercy of the local police station where the ACP is the topmost. And in the middle of the night and at all hours, who is going to be our judge? The person in the police station. So we are at that mercy. So what I'm trying to say is that the training of these police people and the changing police force, very often it is seen that the local police station is not really thorough about Jacob Matthews, etc. Though it is well said, they are not very thorough in about the retrieval of organs, or what I meant to say, the act, etc. And being the senior most doctors are at their mercy. So this other thing is, besides changing the law, besides giving guidelines for severity and classification of civil criminal negligence, training of the police force, and that too of the foot soldier, literally, because we all are going to deal with foot soldiers, and the ongoing training because of the turnover and the transfer of the police station, this becomes an important criteria. Thank you so much for the opportunity.
Thank you very much, Dr. Sugandhi. As always, crisp. I think on the doctors, if I were to classify this as a T20 amongst the doctors team, I think we've had Sachin Tendulkar throughout, and we have no less Sachin Tendulkar to end this batting for the doctor's points of view to be put forth in a clear and lucid manner. I have Dr. T.N. Ravishankar. Dr. Ravishankar is a faculty in medical laws at the Anna Institute of Medicine, Chennai, and also at the Sri Ramchandra Medical College and Research Institute, Chennai. He is the founder member of the Professional Protection Scheme of the Indian Medical Association of the Tamil Nadu state. Dr. Ravishankar, it's always a privilege to hear from you. Your views in the next 3 to 4 minutes, please. So over to you.
Am I audible?
Yes, Dr. Ravishankar, sir.
Thank you. Thank you. It is always difficult to follow Sachin Tendulkar's batting. You have said already Sugandhi, Madam talk. I think I have to be very crisp. I think umpteen number of landmark judgments in this country has been pronounced, but still that has not been followed up properly either by the bureaucrats or by the medical association, which has resulted in present days debate, discussions, pathetic situation of losing a doctor because of a criminal law. this profession has only three outcomes. Either the patient lives the life or has a mortality, morbidity, or a morbidity and finally death. So when there is a morbidity, the patient goes to the court, try to get money out of it, trying to prove a civil negligence. Or if there is going to be a death, it is going to create a knee-jerk reaction by the public trying to assault the hospital and take the doctor to a ride, and that is where the assault has come, and today we are seeing the same scenario. IPC have a lot of sections. Whenever you go to the government, they always say there are a lot of sections where by which you can take to task all the people. And then there is an excellent IPC section 80, accident in doing a lawful act. Law gives me the right to practice a profession, but where is the law coming to defend me when section IPC 80 is already there? 304, 304A was all enacted, not using the medical profession when it was enacted decades ago. It was primarily for the road traffic accidents, which has been imposed on the medical community when the medical community was in slumber. When FIRs has been filed against some at random in the country, had the medical community come into the action at that time, things would have changed a lot. And the excellent statistics given by Dr. Mukul has given some more thoughts for us that the socio-economic, cultural status of the society also will have to be looked into it. And you want to defend the medical community, both by the civil as well as the criminal law. See, all we need, I thank Dr. Shrikant Shetty for recollecting my medical tribunal, which I have done it for the Indian Medical Association almost 12 years ago, and it has gone to the dustbin, but still there are people. I still always enforce that medical tribunal is one which can help the medical community in one way or another. There are two things which are harassing the medical community. Consumer Protection Act, where Dr. J. Kishan already has said that the administrator should say the medical community is out of the Consumer Protection Act. It cannot happen in a democratic country. And there should be a ways and means where it is much more easily approachable, both for the medical community and for the society also. That is why I envisage a medical tribunal where things have to go fast. When you have a tribunal for the administrators, when you have a tribunal for any more in the labor and all these things, when you want the things to expedite, there are law in the country which takes nearly 2 decades for a consumer case to be completed. I think that is going to give a sword hanging on the head of a medical professional. We need a medical tribunal which gives shorter time, easier way, both for the doctor as well as the public to approach, get things done. And we have only 10% or 7% of cases in the country against a doctor. You can have a medical tribunal running around the entire country trying to settle the issues at the earliest, so that both the doctor as well as the patients are being taken to the right perspective. And then hospital should be, when you have the defense area protected, and you have section 144, which prevents more than 8 people assembling at a point, I think hospital should also be labeled as a protected area, given the security, given the safety for the medical professionals and our allied people to function properly, all the ease. That is why you need changes in the IPC section, that hospitals should be made a protected area, and people who indulge in violence, either verbally or physically or in any other way, should be taken to task. And this law should be educated. I think it is our responsibility to educate the public, at least take a year forward, try to educate the public that if you damage a hospital, if you involve doing anything against the hospital, you will be taken to the law under our medical establishment protection bill in the country. We want a central act so that it is being much more strict and stringent. If these are not being provided, I think slowly the medical community will get vanished. You have the family practice are vanishing in the country, becoming a specialist country, and then slowly the doctor community also will slowly get vanished in the society if the medical community and hospitals are not protected in the right way to practice the profession with all ease and liberty and to the best of the patients in this country. Thank you for the opportunity. I am in.
Thank you so much, Dr. Ravi Shankar. I think you've made an extremely clear point, and I will just refer to yesterday's news article where the Honorable Union Minister for Health has removed protection from the Lady Hardinge Medical College, and we have the resident doctors up in arms. Obviously, there is a fear because of past incidents. All of us carry our baggage of past incidents, our experiences, and that's what's leading us to ensure that this doesn't happen again ever. Now we move over to the patients group. You see, patients are inevitably the focus of our entire effort. You know, we work every day and we don't sleep at night because we're thinking about our patients. So we'd like to talk to two representatives of patient groups to understand the patient's point of view. I'd like to start with Dr. Ratna Devi, who is the CEO of Dakshayani and Amravati Health and Education. She's also the past chair of the International Alliance of Patient Organization, the IAPO. Over to Dr. Ratna Devi. Do we have Dr. Ratna Devi? No.
She's
Okay.
here. Maybe she may be just out for something.
Okay, so with my constitutional right of moderator allowing to move on to the other esteemed representative and a very old friend, Dr. Sanjay Nagral. Dr. Nagral is a senior consultant and director with Jaslok Hospital and publisher of the Indian Journal of Medical Ethics. Dr. Nagral, over to you for your views on this topic, sir.
Thank you, Parag. Can you hear me?
Yes, you're audible, Dr. Nagral, sir.
By the way, do you realize you just promoted me to director of Jaslok Hospital? I'm not.
That's the code that's given to me.
I'm just heading one department there, so no issues. So look, first of all, let me start by saying that it's interesting that you have slotted me as a patient representative, and I know where it comes from, and of course, I kind of take that responsibility. But as a doctor, so I first want to remind whoever is listening to this that I very much belong to the beast of the belly of the beast of Indian healthcare, which you know. So I practice surgery every day. But of course, I would also accept that with my interaction over the years and my engagement with what may be generally termed the bioethics movement or the health rights movement in India, which is of course very different from medico-legal. So the term medico-legal is very narrow. Ethics is a much more broader term. I have had an opportunity to hear the other side. I have had an opportunity to kind of understand the concerns of patients, their families. May I just also remind everybody on this panel that these distinctions of doctors and patients, and I think Susan Sontag put it very well when she said that we are all born with two citizenships, the well and the sick, and that at some stage in our lives we'll all be patients. I just want to start by therefore saying that, of course, it is excessive, wrong, and counterproductive to use a tool, casually use a tool like arrest for a perceived act of medical negligence. And it can only increase the mistrust between professionals, the state, and our citizens, which is not good for everyone, including patients and including for the practice of healthcare. But may I also suggest in the limited time that I have that to understand this phenomenon better, we may want to consider the following. Number one, arrest as a means to respond to presumed or perceived negligence is actually reflective of the cavalier attitude of our law enforcement authorities. And in fact, most of us are shielded by this behavior in our day-to-day lives. We are the elite of this society. And we get surprised when this happens to us. But ordinary people in this country face this all the time, that based on flimsy grounds, people are arrested. Number two, and I say this with some sense of trepidation but responsibility, that actually the way law enforcement agencies behave may be a reflection of a certain lack of trust, a certain even anger, if you would like to put it that way, of the image of the medical profession currently being as very corrupt and also often willfully negligent. And there is a difference between negligence and willful negligence. So therefore, I suggest that for a discourse like this, whilst we today want to focus on the issue of arrest and negligence, and of course, that is a very important issue, but we may also want, therefore, in any such discourse to touch upon the elephants in the room, at least acknowledge them, which is the lack of universal healthcare in this country, the costs of care, the perverse incentives that are offered by a privately dominated system, the relative inactivity and lack of credibility of our professional and regulatory organizations. And I do not want to go into the history of the Medical Council of India, but it is there for everyone to see. Incidentally, I just had an opportunity to participate in the a committee of the National Medical Commission, which is looking at how to coming out with a new ethics guideline. And I participated in a committee which is looking at what should be the penalties. And it was quite an interesting experience and quite an enlightened experience. Finally, I want to say that I do not think, with my experience of about 30 years, that a large majority of our patients perceive negligence and error every time there is a complication or every time they die. What they often want is an explanation, empathy, transparency, and maybe in certain situations, a concession or a compensation. And I think we may be making the mistake of remembering those few incidents where we have been at the receiving end, when actually thousands of our other patients, in my view, are actually very tolerant to the inadequacies of the system. We are doctors and we have our limitations, but our system is inadequate. And the average citizen in this country has to face the inadequacies of the system. Do not forget COVID and the lack of oxygen. I also say this, Parag, because I do not want anybody listening to us today, a young person especially, to think that the medical profession in this country is sort of something they do not want to pursue. I would suggest that practicing medicine in India still is an extremely satisfying experience in a large majority of situations. Finally, Parag, and this is something you will identify with, that very often people are aggrieved because the normal mechanisms of complaining, whether it is hospitals, whether it is the local medical councils or other regulatory bodies, do not attend to complaints either immediately or with transparency. And this is what sometimes may push them to take it further to courts. And there are umpteen examples of this. So in summary, I want this panel and today's meeting to also finally, as a concrete suggestion to my legal colleagues, suggest that we need sharper definitions of what is poor outcome in medicine, what is error, and what is negligence, and what is criminal negligence, whilst accepting that there is indeed a small percentage which constitutes criminal negligence. And if we are in denial of that, we will not move forward. Number two, we need to distinguish between structural and personal negligence. Structural negligence of our healthcare system, which is inadequate, versus negligence of the doctor. We need to have a process for investigation of perceived negligence, which is transparent and which is not riveted by conflict of interest, which means 5 doctors don't sit together and decide about a 6th doctor, but that it has diverse representation. And finally, before I finish, I think we need slowly to move to the idea of compensation as opposed to negligence, because globally, a person who has had a complication has and ends up spending a huge amount of either money or time or disability is compensated. And I think we need to seriously look at compensation as an option in our situation. Thank you for your attention.
Thank you, Dr. Nagral. And I'd probably like to add, since we don't have access to Dr. Ratna Devi right now, I'd probably like to add a couple of points which should be taken up as the responsibility of healthcare providers in toto and doctors in particular. I think there is an inherent responsibility of hospitals, doctors, to be transparent to their patients. This is part of the Hippocratic Oath. This is part of the entire ethos of healthcare. And I think this is also a risk mitigation defusing kind of strategy, which most doctors and hospitals do get into. There are hospitals today which train their doctors in crucial communication, how to break bad news, how to do it sort of with a lot of empathy. So while we move towards the legal sort of safeguards so that doctors don't get punished, I think it is equally important that doctors and hospitals own up to explaining things the way they stand and do counseling in a timely and extremely honest and transparent manner. To that end, Dr. Nagral, sir, I would agree with you. And I think that's something which we should also be putting in somewhere as part of this white paper that we're moving towards. I'd like to move on now to the next team in this T20 match that we're looking at. And I also recognize that Dr. Utture has a time limit that we need to get to. So, but before that, I'd like to speak to my lawyer colleagues. Extremely senior, extremely proficient. I'd like to start with my very old friend whom I've been interacting with over the last 10 years, Advocate Mahendra Kumar Bajpai. Dr. Advocate Bajpai is a practicing advocate at the Supreme Court and the Honorable Director of Institute of Medicine and Law. Probably one of the few people whom I know who understands the nuances of medicine as well as the fine nature of law with exceedingly equal sort of diligence. Over to you, Advocate Bajpai, your point of view from a legal standpoint, sir.
Thank you, Parag. Friends, today I will try to raise 4 questions and try to answer them. Question 1, why should there be a special protection to any particular person or a group of persons? Question 2, why as a category doctors need to be protected? Question 3, is the protection given to doctors by Jacob Matthews enough? And question 4, is there anything else that needs to be done? The first question, why should there be a special protection to any particular person or group? And I'll be answering all these questions as a lawyer. The answer is simple. If there are justifiable reasons, then the state is bound to discriminate positively under Article 14 of the Indian Constitution to give special incentives, concessions, protections to a particular person or an identified group. It is the state's responsibility to do so. Law not only provides special protection only to weak and vulnerables, children, old, ladies, backward regions, and so on. There are so many privileges and protections that law gives to them. But at times, law also provides protection to important and powerful ones. Judges are protected, parliamentarians are protected, media is protected. A week back, a member of parliament, Mr. Subramaniam Swamy, he went to the Supreme Court. My protection is not there. It is the public policy, the greater good, the probable disastrous consequences to the society, which are justifiable reasons for providing protection. We come to the second question. Why, as a category, doctors need to be given a special protection? The reasons given by Justice Lahoti in Jacob Matthews case, and my very good friend Mayank Kshirsagarji just now reiterated a few of them, were good yesterday, are good today, and will remain good tomorrow also. These reasons are universal. They are relevant in India and for that matter in any other country where medicine is practiced scientifically and is evidence-based. Let me add another reason, a pragmatic one, India-specific. Many panelists have already put light on that. Doctor-patient ratio in our country is dismal. Why should an academically brilliant student opt for medicine as a career? This is actually happening and the worst is yet to come. To make matters worse, will the threat of prosecution work as a reason for doctors to practice abroad? Go away from India, where life is a bit easy. These aspects require serious contemplation. There is a counter argument to why doctors should be protected. And the counter argument is, hey, look, there are doctors out there who are playing with the lives of patients. They are negligent. Their protection must be removed. But then there are black sheep everywhere, even amongst the ones who have special protections. Journalists, parliamentarians, judges, media people, everyone. So should their protection be removed? The loss that would be caused to society by removing these special protections will simply be unbearable. Lastly, friends, doctors were always treated specially by law in India. Jacob Matthews' protection is simply unique, unparalleled, salutary. Indian Penal Code was enacted in 1897. Justice Ganguly spoke about section 88, 92, 93. Specific illustrations are appended to the provisions where doctors' medical practice, they have been defined and described. Privy Council way back in 1943, it was the highest court in India before independence. In one case, John Oni Ackerley versus the King, it has observed, and I am quoting the relevant excerpts, quote, the most favorable view of the conduct of an accused medical man has to be taken, for it would be most fatal to the efficiency of the medical profession if no one could administer medicine without a halter round his neck. In 1943, these were the observations of the highest court in India. So the second answer is very clear. Doctors were always treated specially since time immemorial and across jurisdiction. The third question, is the protection given to doctors by Jacob Matthews' judgment enough? Answer is also very simple. More needs to be done. Because in the last 17 years, we have seen certain loopholes. Last one coming 6 months back from Rajasthan. Jacob Matthews' judgment to a very large extent has proved to be very ineffective. Let us not forget that in police complaints, responsibility was cast on the policemen by Justice Lahoti to get an opinion from a doctor in government service, a doctor of the same speciality as the doctor accused of negligence, a doctor who knows what is Bolam's law, a doctor who knows what is negligence in the eyes of law. Jacob Matthews intended to plug the spaces for any mischief. Unfortunately, in some cases across the country, the investigating officers, the policemen, are adding other sections of IPC along with section 304A only to bypass the legal hurdles posed by this judgment. The Rajasthan episode is simply unexplainable. So something further needs to be done. What needs to be done happens to be the fourth question. Two suggestions. First, although Jacob Matthews advises the government to come up with statutory instruments on this aspect, I would suggest that an amendment to the IPC or the CRPC would be the best way. Second, some sort of a certification from the Superintendent of Police, from the Deputy Commissioner of Police, an IPS officer, must be taken by the investigating officer. Dr. Sunit Upadhyay just now shared with us that they had approached the SP and the SP said, yes, I know that. Let it come on paper. The investigating officer must be bound to take permission, official permission from an IPS officer before filing of FIR against a doctor for criminal medical negligence. Lalita Devi also runs on very similar lines, something more than Lalita Devi. And this procedural safeguard will ensure that doctors are protected from false and frivolous prosecutions. In fact, in the recent sedition case, a similar procedural safeguard was suggested across the bar in the Supreme Court. Friends, that is all what I have to say. Thank you. Thank you for giving me an opportunity to speak. Over to you, Parag.
Thank you very much, Advocate Bajpai. I'd now like to move to Dr. M.C. Gupta, who is a doctor turned lawyer. He's a practicing advocate with health and medical law as the area of special treatment. I think at some stage, we'd probably like to request the lawmakers to try and see that doctors and advocates practice both professions together, which is currently not allowed. But that's a side note. Dr. M.C. Gupta, sir, over to you, sir. You have 3 minutes to give your views, sir.
Okay, thank you. Am I audible, please?
Yes, Dr. Gupta, sir.
Okay. Now, since time is short, I will straightway come to the topic, and the topic is whether any changes in law are needed. I have listed 8 changes, and I will come to them briefly one by one. Number 1, which is engaging attention of doctors nowadays recently, is about the FIR. Now, they say that FIR against a doctor should not be registered unless there is a compliance with the Jacob Matthew judgment by getting an adverse report from an expert. But to me, the position is clear in view of the Lalita Kumari judgment, where the Supreme Court has clearly said that if there is a cognizable offense, then the police is bound to register FIR within 7 days. Later, they increased the period to 14 days. And then they said that during these 7 to 14 days, the investigating officer can undertake a preliminary investigation. The problem is that this preliminary investigation contemplated in Lalita Kumari is being confused by doctors as being the investigation suggested by the Jacob Matthew case. The preliminary investigation by the IO is only to the extent that if he is not sure whether it is a cognizable offense, then he can take time up to 14 days to decide. If he decides, if he determines it is a cognizable offense, he has got to register FIR. So I think there is a need to make it more clear by way of some amendment of law, so that this confusion does not prevail anymore. Second point, there about 20 states of India have got laws against violence against doctors. The real fact has been that very few cases are registered, very few complaints are registered with the police under these laws. There is a need to bring out a central law for prevention of violence against doctors on the lines of the 20 state laws. Andhra Pradesh was the first one to bring that law. Third point is about the National Medical Commission / Medical Council of India. Very surprisingly, the rules of the National Medical Commission, they say that if an adverse opinion or if the Medical Council has given a judgment, only the doctor can file an appeal. The patient party cannot file an appeal. Surprising, extremely surprising. They need to change that. Similarly, I have got on record with me an answer to the RTI where MCI said they do not have any guidelines to ensure that the punishment given to a doctor is proportionate with the gravity of his offense. They need to come out with guidelines. Fourth point is very important. This is about the Clinical Establishments Act 2010. Those who have read this act, and section 12 of the act says, if a patient comes or is brought to the emergency to a clinical establishment, then he will be given emergency treatment till the time the patient is stabilized. And there is no mention about who will pay for it. A patient may come with burns, multiple stab injuries, whatever it is. He can walk into the hospital, and claim that I must get free treatment, because the Act does not speak a word about who will pay for it. Surprisingly, this is in spite of the fact that the Law Commission of India, in its report in 2001 and 2006, report number 201, it has clearly stated that the government must come out with a law to ensure that while the treatment is given in emergency patients, it must be compensated. Doctors of hospital giving that thing, they must be compensated for the services. There seems to be an impression among the legislators, even judiciary, that doctors, they need to be giving charitable work. Supreme Court a few years ago, in a judgment, had passed directions when a patient, female patient, when a patient comes with burns injuries, acid throwing, etc., whatever it is, or burn injuries, then the doctor must provide reconstructive surgery, plastic surgery, free. Doctors know, even the laymen know, how much difficult and strenuous job it is to provide reconstructive surgery. But they pass the judgments. I do not blame the Supreme Court even for such judgments. What is the IMA being doing? What is the MCI being doing? They keep quiet. They keep quiet. They don't protest. Anyway. Now, the point about special tribunals for medical legal cases, negligence cases, yes, that point is correct. I agree with that. Something must be done in that regard. Then, it was mentioned also by one of these people. There is a 1996 judgment by Supreme Court, Haniraj Tulani versus Bar Council of Maharashtra and Goa. In this judgment, the Supreme Court has held that if a doctor or if somebody is having a professional degree, like a doctor, he will not be allowed to practice law if he has got a legal degree also. He won't be allowed to practice law and join the Bar Council unless he gives up the previous profession. The pity is that such a bar does not exist in any other common law country. USA, UK, Canada, Australia. Why here? It was never pleaded. This point was never pleaded. I have been talking to personally I have been talking to the residents and secretaries of IMA national level.
Dr. Gupta, kindly take 20 seconds to wind up, sir.
Yeah, okay.
Thank you.
And they agree, but no one else. Now, just last point. PNDT Act. As per the PNDT Act, if a complaint against a doctor is pending before the PNDT authorities for violating the PNDT Act, there is a provision that the registration of the doctor will be suspended for 5 years by the medical council, even before any judgment comes. So these are the 8 points I wanted to mention regarding where changes are needed. Thank you.
Thank you, Dr. Gupta. I'm going to move on to Justice Ajay Kumar Mittal, sir. Justice Ajay Kumar Mittal functioned as the acting Chief Justice of the High Court of Punjab and Haryana. He was also Chief Justice of the High Court of Meghalaya and then Madhya Pradesh. He is on the Board of Governors of Chitkara University. Honorable Justice Ajay Kumar Mittal, sir, may I request you to kindly render your views in the next 3 to 4 minutes, sir.
A very good morning, ladies and gentlemen. But before I say that, I'll just like to point out, hardly there is any time left. It's already 11:45. So can I speak or something? Or the time is already over?
No, sir, we have time, sir. We will probably skip the second round, but you have time. Please take your time, sir.
Okay. Of course, first of all, I commend the 7th Medical Convention on Medicine and Law that you have called this convention, which is commendable job. And since the time left is very little, I'll just like to go to the suggestions instead of pointing out certain things. Law, etc., has already been discussed by various panelists earlier. So one thing I'll just like to say is that balance has to be evolved between the rights of the patients and protection of doctors from frivolous and unwarranted prosecution. And before proceeding under criminal action, there should be reference to the Medical Council of India, or where there is, it's a state case, the Medical Board of State, to examine consisting of 2 prominent doctors of the subject within time-bound manner. Because since the lawmakers are also there, so I would like to make this in a very short nutshell only. Then, in case of government hospitals, extra care is required for prosecution, as at the time of employment or engagement in the hospital, the recruitment authorities verify all the credentials of the doctor. So once that is done, because unless there is protection to the doctors also from unwarranted prosecution, they will not be able to perform and give their best. Difference has to be drawn between professionally qualified doctor and a quack, because normally the idea behind prosecution was that only those who do not have the proper degree, they should be prosecuted, not that a highly qualified doctor, because what happens is on a number of occasions, the chances of survival of a patient may be very minimal, but still the medical procedure has to be performed on him. If a doctor is under the threat that there will be prosecution, then he may not be able to accept that operation and do his best. And as Dr. Yadav had said, and even Mr. Vajpayee, I also endorse that. My view is that there should be, so far as IPC is concerned, it should not be left to general provisions of like 304A, 302, 337, 338, etc. There should be a specific provision, like in gang rape cases, etc. A special provision has been made, like 370G, 2D, etc. So same way, there should be a specific provision for prosecution of doctors, so that at least they have safety. As it was being pointed out, one of the speakers said that in case of a doctor, there was 302 case filed against him and he committed suicide. So that should not be there. That fear should not be there in the mind of the doctors while performing the operation. Similarly, like CRPC, there should be proper amendment there also. Before lodging, it should be properly scanned whether it's a case for a lodging of FIR or not. And more important is the Evidence Act, because it was being pointed out that Evidence Act has to be done. But there I would say, give a suggestion actually, a presumption should be raised, incorporated in favor of the qualified doctor, which may be rebuttable, that in case they are negligent, the patient can rebut it. Suppose A treatment was to be given and that was the only treatment which could have been given, but instead a patient has been treated for B. Then in such a case, that presumption would not come in his way, but it should not. The presumption should not be conclusive. And and there should be, for so far as accountability of the complainant and the officials should also be imposed wherever there is a frivolous litigation or that filed, because otherwise doctors and patients are not generally seen as adversaries, and actually doctors are seen as healers and savers. But with commercialization, this relationship has not retained the age-old sanctity that is a matter of great concern to the medical profession. So for that reason only, this medical prosecution and under the Consumer Protection Act started coming there. So my submission to suggestion to the lawmakers would be that IPC, CRPC, and Evidence Act should be, there is no requirement of any separate new act. Only thing is, these should be amended with separate provisions for negligence of the doctors. And
thank you very much.
Yeah. At the end, I'll say thank you very much for inviting me. Thank you so much.
Thank you very much, Honorable Justice Mittal, sir. I take this opportunity to move forward to the regulatory group. I'll come back to Justice Ravi Tripathi, sir. I believe Dr. Shivkumar Utture has a prior engagement. Dr. Utture, he is the president of the Maharashtra Medical Council, the licensing authority for doctors in Maharashtra, and also a member of the National Medical Commission. Dr. Utture is also a surgeon par excellence. Sir, your views, sir, on this current topic.
Yeah, thank you, Dr. Parag. And at the outset, I should thank IML and Mr. Ravindra for having invited me here today on this, important topic. And let me tell you, 10 years in the council, it is just recently that I'm finding more and more organizations talking about medical legal aspects. Otherwise, before this, we used to rarely talk about it. I think I should congratulate both the legal team and the medical team for taking this initiative. Now, today we are here to discuss basically about the criminality of the aspect of negligence. So I'm not going to go into all the ethical aspect and, how we should communicate and all with the patients. So I'll just, with your permission, do a little bit of screen sharing.
Sure, sir.
Yeah. So basically, what we have to understand is sitting in the council for the last 10 years, let me tell you, interacting with thousands and thousands of doctors. All the doctors say they are basically mortally scared of only two things. One is being assaulted, beaten up by the patients or the relatives. And the second thing is when a criminal case is filed against these doctors. And that has a very wrong effect, a psychological effect on the doctors. And I've seen many doctors who have left their practice just because of this problem. Having said that, I'm not saying that there should not be any cases filed or as far as negligence is concerned, because statistics shows that a lot of negligence is being taken place. So, but there has to be a balance and this is what the judiciary has also done over the years between the patients and the doctors. So I'm not going to go into the details because a lot of the luminaries have already gone through these details. But one thing I would like to point out is that there is a difference between negligence, which is on the civil side, and negligence, which is on the criminal side, which has been defined as gross negligence. And this is one thing I think which people do not understand. And especially, when committees are formed in the medical colleges to decide on negligence, their reports, which I have seen, just states that, yes, there has been negligence. But is there gross negligence? Nobody opines on that, because if there is gross negligence, only then it should go as into the criminality of the negligence. Otherwise, the rest of the negligence falls into the civil domain. And this has been told even by the honorable judges in many judgments. And even if you see in section 304A, the word gross has not been used at all. So again, there is an ambiguity as far as what the court says and what has been written in section 300 and 304. There is the Jacob Matthews case. I'm not going to go into the details. Katara case also, everybody has spoken about that. But what I would like to point out that even in the Martin D'Souza case, the judges have also said that if the police officers, arrest or harass a doctor without clear facts being noted down as far as the Jacob Matthews case, then these police themselves will face legal action. And that is, I think, what should be done also in this case of the unfortunate Dr. Archana Sharma case, which is there, that, they have to be taken to task as far as, this judgment, which is already there over there. But let me tell you, just depending on the judgments is not going to help at all, because many a times we find that there is a, difference in interpretation of the judgment by the different courts. And not only that, but even the IPC, just as it was pointed out, that can an FIR be filed? Half the people were saying that it cannot be filed unless it goes to, a committee. Whereas section 152 says that there is mandatory FIR has to be filed if it is a cognizable offense. So, police file that FIR taking, recourse to this section 154. And even if you see, wrong diagnosis is not negligence. But if you see, there are two judgments, one given by the Supreme Court, which says that wrong diagnosis does not constitute medical negligence. But there is a Kerala High Court judgment which says that wrong diagnosis is an act of negligence. So, this is the ambiguity is there when we are dependent only on these judgments which are there. And therefore, the requirement for having an amendment is definitely there as far as this criminal negligence is concerned. Now, this is one thing which I would like to point out to all, I think, erstwhile members who are over here and even the medical fraternity, that in 2021, as per whatever the Jacob Matthews case has said, in that the judge had asked for the opinion from the government and the MCI. At that time, even the MCI, as well, MCI had given their opinion. But in 2021, from NMC, we have given our opinion to the government. I don't know what has happened after that, if the government, I think, has given it to the Supreme Court, but it has not yet come as far as on the floor of the House is concerned. And what does this say? We have very, very specifically given us the format of when an FIR can be filed and when an arrest can be taken place, where it clearly says that prior to making an arrest, refer the complaint to a district medical council board, which has to be formulated by the state governments as regards to the merit of allegation of criminal rashness or negligence contained in the complaint. So it has to be primarily sent directly to the district medical board. Then the district medical board gets 2 weeks to come to some decision and give their opinion on that. And if the recommendation by the district medical board is not acceptable by the investigating agency or by the doctors, then they can refer the matter to what is called as the state medical board for its recommendation, which again should be given within 2 weeks. So there's a two-tier system it can go through, where the boards can tell you that if it is a medical negligence or not. And this has to be appointed by the state government. Even who has to be appointed on the boards has been specified over there, that there will be 2 specialists of the concerned branch on which the doctor who has treated that patient should be included in the board on the day of receipt of the complaint or the appeal. Now, what we also have said that the state medical board shall provide reasons for endorsing or rejecting the recommendation of the district medical board. And in case of an arrest of a registered medical practitioner in employment of the government or a central government, their controlling officer should also be informed. And if it is a private practitioner, the state medical council is supposed to be informed. So there is that aspect is also there over there. And unless the alleged negligence is of gross nature, we have used the word gross over here, and arrest is necessary for furthering the investigation or for collecting evidence, or where the IO feels that the doctor will be running away or whatever, only then he can arrest. Otherwise, the boards have to apply the Bolam's test. Again, this has been reiterated by the National Medical Commission also. Then we have also said that the permanent members on the board should change every 2 years. It should not be a permanent board which should be there. And the permanent members of the board should be changed. Not only that, but they should be the DGHS or the civil surgeon officer should also be part of this board. So these details have already been sent to the government from the National Medical Commission in 2021, and I hope the government goes ahead with accepting these. Unfortunately, over here we have not again defined what is gross negligence. So my suggestion would be that yes, Supreme Court has framed guidelines for seeing medical cases, but we require to have amendments in the IPC itself, so that it is followed by all the investigation officers all over India. Not only that, we need to be very clear and concise provision to define criminal medical negligence, especially clarity on what constitutes gross negligence. Because nowhere have I seen, I've gone through all the legal judgments, I've gone through all the IPC, nowhere what is gross negligence has not been defined. So what we require to do as a group is to define what is a gross negligence, and then medical courts need to establish where the medical experts should be appointed to assist the judiciary. And this is the concept of this medical tribunal, which is being put forward by many members, comes forward. And I am sure that medical tribunal will go a long way in not only helping the medical practitioners, but also the patients to understand that justice is being done to them. So thank you very much for giving me this opportunity to put forward my views as far as this criminality of 304 is concerned. Thank you.
Thank you very much, Dr. Uttare. And I'd like to now invite an extremely senior professional and extremely senior functionary, the Additional Director General of the Ministry of Health and Family Welfare, Dr. Jitendra Prasad, who has been associated with a lot of the changes that we are seeing in the healthcare scenario of the country. Dr. Jitendra Prasad, sir, over to you for your view, sir.
Good morning, sir. Good Respected Chair, Honorable Judges, and distinguished participants. First of all, I would like to say that when a medical student, after completion of his study, gets the license to practice in the field of medicine, he owes certain duties towards the services over the mankind. And if there is something, absence of reasonable care and skill, or there is breach in the duty, then the treatment of the patient, that gives a patient to the right to initiate action against the medical negligence. Thus, a doctor must exercise an ordinary degree of skill. However, they cannot guarantee of cure. If he has adopted the right course of action, he is skilled, has worked with a method and manner best suited to the patient, he cannot be blamed for the negligence, even if the patient is not totally cured. All death and negative outcomes of the diseases with good care cannot be considered as a negligence. I am totally agreed with the opinion of Advocate Mahendra Vajpayee that opinion of Dr. Professor Shiv Kumar that gross negligence word which has been used in the criminal negligence, it has to be clearly defined. What are the conditions in which gross negligence should be proved? Number one. And number two, before prosecuting a doctor for criminal negligence, a group of experts in the field of concerned specialty, along with senior police officers of the rank of IPS, at least senior superintendent of police, their permission and opinions should be taken before prosecuting a doctor and lodging an FIR. This is my opinion, sir. Thank you. Thanks for your invitation.
Thank you very much. And I'd like to move to Dr. R.K. Aneja, who is the president of Haryana Medical Council. Dr. Aneja. Ravindra, is he there?
I don't think so, sir.
Okay. And I had kept my favorite justice, whom I've been listening to for the last 5 years, Justice Ravi Tripathi, sir, for towards the end of this. And I'd like to now give a total of 5 whole minutes, sir, with whatever meager resources I have. Over to you, Honorable Justice Tripathi, sir, for your views on this topic. You've been seeing changes over the last few decades, and we'd love to know your views, sir.
Good afternoon to everybody. Friends, it's very interesting to listen to the dignitaries and luminaries of the field. I'm really thankful to the organizers for giving me this opportunity to be there. I want to make 2 things clear. First of all, the general opinion which is coming forward is as if doctors should be given a very special treatment and a total immunity. I don't think anybody can agree so far as total immunity is concerned. And so far as special treatment is concerned, I think nobody will disagree with that they should be given a special treatment. And that is what was mentioned by Advocate Mr. Mahendra Vajpayee also, that doctors are a class by themselves and they deserve and they do require a special treatment to be given. Friends, so far as negligence is concerned, a very high standard of due diligence is expected from the experts, doctors, and doctors by themselves is a class, and a very special due diligence is expected from them. And any lack of that, there is a general impression in the mind of the people that they are powerful people, they're influential people, and that therefore they are beyond the reach of the common man. The basic problem is that we have seen a super commercialization of the medical care sector, and that has created all these problems. One of the speakers very rightly said that there is lack of trust and lack of faith in the doctors, then these all problems start. The another panelist very rightly said that if you take percentage wise, you will find that these instances are not even forming a part in 0.1% of the total medical service which is taking place in the country. Friends, so far as a special treatment is concerned, I really wonder why MCI did not move the Supreme Court again after the 2005 judgment was given. In fact, I must congratulate, and that will be right thing, because if you remember about the sexual harassment at the workplace, that Visakha's judgment is very famous, and very important because Supreme Court legislated the guidelines and made the provision that unless the competent legislative body enacts the law on that particular subject, these guidelines will continue to prevail as a law. Same is the case here with the Jacob, and in the Jacob Matthews case also the Supreme Court said the same thing, that the legislative should legislate on this and should provide the guidelines. Now 17 long years we did not move the Honorable the Supreme Court saying that, sir, please remind the legislative body for doing this. Of course, they might have accepted, they might not have accepted, because they had already said that until they legislate, these guidelines will continue. Now, so far as lack of observance of guidelines provided by the Supreme Court by the police personnel is not something which is within the control of the Supreme Court or even the High Court or even the subordinate courts until that particular instance is brought to their notice by the concerned person. And so, one thing is very simple. And there is a judgment of the Honorable the Supreme Court and observations in other cases also, that if the wife is oversensitive and she commits suicide on account of something which she felt very bad about the behavior of the husband or the husband's relatives, the husband is not held responsible for that he abated the suicide of that particular wife. Now, same is the case here, that if a particular doctor has committed suicide, I'm not justifying that suicide was, is done and it is to be neglected. No. But at the same time, if the doctors behave in a very oversensitive manner, possibly nobody can help them. And one thing is certain, I have been repeatedly telling, as you are rightly referring, that I have been associating myself with these discussions for quite long. Judiciary does have, and I repeat, judiciary does have a respect for the doctors as a class. There is no personal grievance to any judge against any particular doctor. But then the difficulty is, we are also human beings. We are living in a society. We have vast relations, and those relations do come to us and tell us that such and such way we were treated in the particular hospital. And this happens not because the personal doctor is, having a particular temperament, but this is because of the staff which is there in the hospital, which gives sometimes a very bad treatment to the relations and even the patient when they are in the hospital for taking the treatment. So friends, one thing is certain, that we do require Jacob Matthew to be now put in a statutory frame, and beside that there should be special provisions for that. Say for example, so far as rape cases are concerned, bribe burning cases are concerned, the court has already provided, and then the statute has already provided, that they will be investigated by an officer of a particular rank and not below that particular rank. Similar provision can be made for the doctors also. And if you remember, in the Jacob Matthews case also, the Supreme Court said that the arrest will be avoidable. Now let us understand very clearly two things. Filing of an FIR, there are judgments of the Supreme Court that they say that police person cannot refuse to accept the FIR and lodge it. But then the arrest is secondary thing. And in so far as arrest is concerned, there are again guidelines of the Supreme Court that arrest should be made only in the cases where there are three things. That particular person is going to obstruct the investigation, he is going to obstruct the collection of the evidence, or that he is not going to be available for the prosecution at a later stage. Only in those cases the arrest is required. In fact, these are the principles which also govern the field of whether bail or jail. So friends, I wholeheartedly agree that doctors do need a special treatment and a special protection, because they cannot be left to the people being attacked by the people, because ultimately it is going to be against the society as a whole. So my friends, I'm really happy that I'm given this opportunity to participate in the debate. I was really enlightened by the views heard by. I wholeheartedly agree with the views expressed by Dr. Negligence and also Mr. Mahendra Bajpai, the learned advocate. Thank you very much.
Thank you very much, sir. I'm going to now request, I would now request Advocate R. Shanmugasundaram, who is the Advocate General of Tamil Nadu State, to kindly render his views on this topic in maybe a couple of minutes, sir.
Dr. Parag is unable to join. He just called me. So
okay, fine. And I think extremely important to go back to the voice of the end recipient of all our services. May I request Dr. Ratna Devi, who is the CEO of Dakshayani and Amravati Health and Education, and also past chair of the International Alliance of Patient Organization. I request you again to kindly come on and kindly give your views, madam, on this topic in the next couple of minutes, please.
I think we'll have to move on, Dr. Parag.
Yeah, I think we had just located her and she is logged in. Okay. So I'd like to open the floor for maybe 30 seconds each in case any one of you would like to render your views. And I'm going to start before I move over and hand over to Advocate Mayank Shirsagar, who's the convener. I'd just like to quickly go through the panelists and see whether there is, maybe we'll start with the doctors. And I'd first like to actually give the floor for a minute to Dr. Sunit Upadhyay. You've heard views, counter views, points of views relating to sensitivity, reactions related to how people respond, and multiple other things, how the society should react. Dr. Sunit, your views quickly in a minute, if you could just quickly give us your rebuttal on any of these points, sir. Dr. Upadhyay? Any of the other doctors, Dr. Gurbir sir, Dr. Jayakrishnan, Dr. Mukherjee?
I want to.
Yes, sir. So just 30 seconds. This is a quick rapid fire round, sir.
Are you saying to me?
Yes, sir. Please, Dr. Gupta, please go ahead. 30 seconds.
I want to make only one point.
Yes, sir.
That as per the very moderate calculations done by me, there are about 17,000 doctors, MBBS doctors in India with LLB degree. They are all debarred from practicing as advocates because the Bar Council refused to register them in view of the Supreme Court judgment. Who is suffering from it, from this judgment? The courts find it very difficult to adjudicate in medical legal matters because they don't have advice. The public suffers because there is no one to argue for them. Everybody suffers, and I think it is a high time that this judgment is reviewed. I have talked to President and Secretary of IMA. Everybody agrees, but someone has to find a mechanism to get the judgment reviewed.
Your point is noted, Dr. Gupta. Any other quick suggestions, 15-20 seconds from the doctors team? Dr. Nagral, I count you in both the teams, sir.
Oh, okay. Thank you. But I need to, can I make a quick comment?
Yes, sir.
Okay, great, Parag. So 2 comments, if you allow. Number 1, we heard today that there is a need for state medical boards, etc. But let me just remind everybody that there's something called the Clinical Establishments Act in this country. And that envisaged the setting up of boards. And I was a member of the state government committee in Maharashtra, which attempted to actually have district level boards consisting, but the difference was we gave a suggestion that it should have civil society representation, patient representation, and doctor representation. That was opposed tooth and nail by the IMA. If Dr. Utture is here, he can respond. It was opposed tooth and nail. So the point number 1. Point number 2, and I want the judges here to respond to that. There is something called conflict of interest. Doctors sitting in judgment over fellow doctors is never going to be looked at as a good process. So we need to open out all these institutions which are looking at perceived negligence to non-doctors. And that is a principle, I think, that is followed all over the world. But here we seem to be very closed, and that makes it even more opaque. Thank you.
Sure. Thank you, Dr. Nagral. From the doctors team, I don't seem to have any further opinions or
just one point.
Yes, Dr. Jayakrishnan, 30 seconds.
Yeah, the thing is that first thing we should require special law till a new law is formulated. The medical council, like the government servants for arrest, it requires permission from the government. Similarly, there should be some mechanism to inform or take permission from the medical council before arrest of a doctor. That is one thing. And second thing is how this gross negligence and negligence is classified, the medical council should, the National Medical Commission should come out with a detailed document on that. That is my suggestion.
Okay. 30 seconds to Honorable Justice Ajay Kumar Mittal. Sir, anything at your end that you'd like to add in light of what we've discussed? And subsequently, Honorable Justice Ravi Tripathi ji. Honorable Justice Mittal.
Parag, if you could give me a chance to.
Yes, I will come back to you, sir, in a minute, sir. I can't be accused of favoritism, you know. Honorable Justice Tripathi ji, sir, over to you, sir.
Right. Dr. Nagral was talking a very, relative, most related topic. So far as Bar Council of India is concerned, as a Law Commission of India member, we had an opportunity to recommend our amendments to the Advocates Act. And there we had said that Bar Council of India is also required to be, reconstituted on the lines of the Bar Council they are having in the United Kingdom. Because he was rightly saying that when a doctor is, judging or adjudging the case of another brother doctor, they are always accused of not the fair treatment. Same is the case with the Bar Council of India also. All advocates' cases about the malpractices go to the Bar Council of India, and they are decided by them, which is not considered to be a homogeneous body, right?
Right. No, I think that's fine. We have members of parliament deciding things about members of parliament, police officers for police officers. I think that's the way the cookie is going to crumble in our country, sir. With that, over to Advocate Bajpai for his 30-second rapid comments, please, sir.
Not a commentary, Parag, but just two clarifications.
Yes,
one,
sir.
Justice Tripathi has already given. A recommendation has been made that at least the Bar Council of India should have other professionals also. But let us understand one thing, and this is very specifically when I respond to what Dr. Nagral has said. Professional bodies pertaining to any profession, they will always have the professionals of that very group. So you take the professional body of chartered accountant, you take the professional body of company secretaries, of architects, they are going to have architects. And please understand, these professional bodies will have to look into the negligent conduct. Okay, as a profession, you understand what are the do's and don'ts, ifs and buts of that profession. You are expected to give justice or decide cases transparently. But the charge of professional prejudices, the charge of conflict of interest will always be there. And it's unavoidable, Parag, trust me.
Absolutely, sir.
It can't be a chartered accountant deciding how an advocate works. We know
point
the
noted, sir.
of what we are facing. Similarly, you face it. Dr. Utture had, in fact, raised one aspect that negligence and gross negligence should be defined, described very specifically. It can't be done. World over, you don't have a medical negligence act. It can't be there. Negligence is simply no diligence, carelessness, a higher degree of carelessness. That's all, Parag, that I want to add.
Thank you, Advocate Bajpai. And the last 30 seconds before I hand over to my esteemed colleague, Advocate Mayank Sagar, to Dr. Ravi Shankar, sir.
I just want to quickly add on 3 practical points. Clinical Establishment Act in this country is not uniformly informed in the country. Every state has got a different one. State says you need to keep the case sheets for 10 years. One state says 8 years. The disparity in the Clinical Establishment Act all over the country cannot be made to be mandatory for the medical professional. 1. Number 2, communication and transparency is the acquisition of the patients only when they are not satisfied, when things go the other way, and when they are asked to pay the bill. This is communication and transparency. If there is not that hospital or the doctor, he has got all right to shift himself away from the hospital to the place where he is comfortable. That is what Dr. Kunal Shah did from going from Amray to Breach Candy. Why don't people follow that? If they are not satisfied, they should go out of the hospital, take their own decision. Why should they accuse it at the time when they are not satisfied or when the time they are asked to pay the bill? Last, all these things will happen. They don't pay the bill to the hospital, get away. what is there in the law for us to recover the money which we have spent on at least on the infrastructure, leave alone the professional on the infrastructure. Thank you for the opportunity.
Thank you, Dr. Ravi Shankar. Pashcham Buddhi Brashta, as they say in Sanskrit. It's always nice to reflect in hindsight. With that, I'm going to conclude my role and render a vote of thanks to all my esteemed participants and hand over to convener, Advocate Mayank Sagar. Advocate Mayank Sagar, sir, over to you, sir, and then subsequently over to Dr. Ved Prakash, sir.
Thank you, Dr. Ridani. It was a very detailed and a very informed discussion, and we all are very delightful to have all sort of inputs. And I would just sum up in 5-10 lines as to what is the outcome or what basic points that were highlighted in this session. Basically, there has to be a balance between the life of patients and protection of doctors from these unwarranted proceedings. As we see, there is a large voice that has been echoing in this discussion as regard establishment of a special tribunal for medical negligence cases, which will also encompass not only the criminal cases but also the civil cases. There is also a dire need to cap the compensation that has been awarded and the circumstances and guidelines as regards award of compensation in the medical negligence cases. Apart from that, there is a need to define gross negligence that has been echoing in many suggestions that have come forward today. Apart from all these aspects, the reanalysis of provisions that are already existing in the IPC are also required to be recommended as to how those provisions have to be interpreted. And not only this, we also have to counterbalance what protection is required and what safeguards are to be given while making our suggestions as regards the amendment that we are proposing and as regards the Jacob Matthews judgment, and what more needs to be done apart from Jacob Matthews and various other judgments that have been discussed today. Another need that I feel that has arisen out of the discussion is as regards educating the police officers, not only the higher rank officers like NSPs, the DSPs or the IOs, but also to the lowest of the levels in the police force, because they are the persons who are the first responders. Probably another suggestion that has very well come forward is, instead of a board, the matter should be referred to medical counsel with the case papers and then have an opinion and then proceed further if there is a need for a criminal prosecution. I believe that these are the very good suggestions, and definitely we'll be able to make our suggestions in the white paper, and considering that today's government is taking suggestion, hearing people as regards the various obsolete laws are there, a special mention and a special protection for doctors in the IPC, CRPC and the Relevant Evidence Act part will be able to suggest a few changes and also insertion of few provisions which will help to further our cause for which we all have assembled today. I thank everybody that has been a part of this discussion, and also we are very delighted to have all the views that we have received today. And with this, I would like to conclude and hand over to Mr. Mangal, who can take over from here the session and lead it to its logical conclusion.
I think Advocate Sagar, I'll be closing the thing. I'd request Dr. Professor Ved Prakash Mishra to kindly give his closing remarks, please, sir. Over to you, sir.
Thank you very much. Well, learned participants, you would agree with me that 2.5 hours down the line, it has absolutely been a very enriching and enlivening experience, where very diligent suggestions, critical appraisals, realistic assessment of the prevailing situation and scenario, and a way forward has been diligently crystallized. A civil society is expected to be plagued by prudence, where anarchy cannot have a place in its any form. When Socrates contemplated this, then in that situation, an intricate balance between the rights of anybody and everybody turns out to be a judicious approach, which is the hallmark of a civil prudent society. Maintaining the pace and maintaining the text of this civility, the four poses which were articulated by Advocate Bajpai, and the answers to those four poses, I think, have been diligently evolved in this entire discussion brought out by the learned luminaries with different shades, hues, colors, and perceptions. The core connotation is absolutely centralizable. This is not a phenomena just which is limited to this country, ladies and gentlemen. I'm reading out a paper where the phenomena is almost global in nature and character. And therefore, it is imperative, when the Honorable Supreme Court contemplated guidelines in the Jacob Matthews case, they cannot be taken to be cosmetic. They just cannot be taken on their face value. They need diligent implementation. They are purposive. They are relevant. They are absolutely need-based. And ultimately, they are aimed at achieving certain set out goals and targets. It is in that context, my trust and belief, when I'm wanting to put across as closing remarks, it's an issue which needs to be dealt by efficacious, effective legislation. State enactments, 17 states have already put across prohibition of violence against doctors. Let me put it across very candidly. In continuation with the statistical dimensions which have been very aptly put across by Dr. Mukesh Yadav, none of these acts in these 17 states have proved to be effective in any manner whatsoever. A critical appraisal of that has already been worked out. And it is in that count, it is mandated that a central act seems to be inevitably necessary. That central act contemplates important dimensions which, in my understanding, have been invoked in this discussion is incorporation of Jacob Matthews guidelines in the form of law, both in words and explicit law, preferably not only in CRPC, but corresponding changes in all cogent and relevant laws, including CRPC and Indian Evidence Act. This seems to be the first necessity which is needed in this entire context. This does not mean and should not mean any prejudice of any form to any of the charters of patients and their rights in any manner. That balance is inevitable and that cannot be sidelined under any circumstances. But this is something which is mandated in the present situation and scenario. Alternatively, medical tribunal itself by itself can turn out to be a very efficacious modality, which could also be a beautiful alternative that can be thought of. Ladies and gentlemen, in this short span of time, the way the learned, eminent people from different walks of life have put across their candid opinion, I, from the chair, I have only humble salutations for the same. I take them all as relevant. I take them all as absolutely timely. I take them all of them having been made with absolute degree of sincerity, thoughtfulness, and critical appraisal. I record my endorsement to the same. The cumulative depiction which has been brought out is equally effective, and I am sure that a white paper on these considerations can be taken up and would be brought up, incorporating these various hues and suggestions which have been made, crystallizing them into operable guidelines. I had the fortune of being the chairman of the committee which articulated the report on Jacob Matthews guidelines being incorporated in law way back in 2018 on behalf of the Medical Council of India, which has been reiterated by National Medical Commission in the form of the amendments which are required to be made, including the nature and wording of the amendment having been worked out in terms of the justification. The document and the report I have already forwarded to Ravindra for his information. Therefore, what I am wanting to put across, the entire deliberations that have taken place, let that be honed down and crystallized down for the purposes of invocation of a white paper, which should serve as a good referral document for the policymakers they be for incorporating a change which is needed, lest really we turn out to be a real, genuine civil society interested in balancing each other's right away from the anarchy, working out in a disciplined manner in the domain of prudence, absolute prudence, and total prudence. Thank you very much.
Thank you very much, Dr. Professor Ved Prakash Mishra ji. And I'd like to now hand over for a vote of thanks to the Chief Operating Officer of Institute of Medicine and Law, Mr. Agastya Matre. Agastya, over to you.
Agastya, you are on mute.
Sir, am I?
Yeah, audible.
Yeah, thank you, Dr. Parag. Okay. Thank you all the distinguished panelists, all the luminaries, the dignitaries, and the honorable judges for joining us today on this very interactive session. We have been fortunate enough to all the luminaries who have graced us for all our NCML. For today, I like to thank Dr. VP Mishra for chairing this convention. I like to thank Dr. Advocate Mahenk Shirsagar for being a convener to us. I like to thank Dr. Parag for moderating this session with this mixed bag of panelists. Thank you, Dr. Parag, once again. Again, I like to thank my team for putting up this very knowledgeable, informative convention. And thank you. All the updates regarding our National Convention on Medicine and Law will be available on medicineandlawconvention.com. We will follow up soon. Those who have registered will get a copy of the report very soon. Thank you so much. Have a great Sunday. Bye.